Parties absent, appearances, please.
May my lord be pleased?
Yes.
I am Kabir Yusuf. I
Yes.
appeared for the claimant.
Yes.
The claimant absent, my lord.
Yes. Any appearance for the defendant, please? Do we have the defendant online? Is he muted?
Respectfully, my lord.
Yes.
My name is Levi. My name is Levi Romusha, my lord.
Yes.
I appear for the defendant.
Court judgment.
Scott, please.
The instant suit was initially commenced by Engineer Antonio Comia Villanueva, now deceased. An order of substitution of the said Engineer Antonio Comia Villanueva for his wife, Rosenda Magnata Villanueva, was granted by the court on the 29th of January 2021 until his resignation. On the 13th of August 2019, the deceased was the operation manager of the defendant. Briefly stated, the claimant's case is that in spite of several demands, the defendant has refused to pay the arrears of salaries, both local and international, of Engineer Villanueva and the allowances he earned while in the defendant's employment. Being aggrieved of the action of the defendant, the instant action was instituted by complaint and statement of facts filed in this court on the 2nd of December 2019 and by amended statement of facts deemed filed by leave of court on the 29th of January 2021. The claimant's claims from the defendant are set out as follows. To save the time of the court, the claims are stated. We have 6 of the claims on the face of the judgment. The defendant disputed the case of the claimant in the further amended statement of defense filed with the leave of court on the 25th of March 2022. The defendant alleged that the purported additional or subsidiary employment agreement was forged, as no such document was made or issued to any of its employees, either expatriate or Nigerian. The defendant contends that the claimant and other members of the union, in consultation with the management of the defendant, agreed for 50% waiver on the salary claims with effects from 8th of August 2017, and further contends that the defendant had paid the claimant's salary and arrears both by cash and through his account up until August 2019. The defendant also contends that the claimant resides in Kano and not in Philippines, that the claimant was not employed as an expatriate, that the holiday flight ticket was never contemplated, and the defendant was not liable to pay for his residence permit and the flight tickets. The defendant denies the claimant's claim in its entirety and further alleged that, as contained in the claimant's first bank statement of account, the sum of $17,885 had been paid by the defendant based on the purported subsidiary employment that was not executed by the defendant, whereof the defendant's counterclaims against the claimant as follows. The counterclaim is as stated on the face of the judgment. We have about 6 or 7 of the counterclaim. I skipped to save the time of the court. The claimant filed a reply and defense to counterclaim on the 30th of February 2021. At the plenary trial, the claimant testified as the sole witness. She adopted a statement on oath and further tendered in evidence 39 sets of documents as exhibits. She was further subjected to cross-examination by the defendant's learned counsel, after which the claimant's case was closed. One Sonny A. Yunusa, the senior accounting assistant of the defendant, testified as the sole witness. He adopted a statement on oath and tendered 3 documents as exhibits. The defendant's witness was also subjected to cross-examination by the claimant's learned counsel. Upon conclusion of plenary trials, parties filed and exchanged the written final addresses in compliance with the provision of Order 45 of the rules of this court. The defendant's final address was deemed filed on the 25th of October 2023, whereby our learned counsel, Levi Shapira Esquire, formulated 3 issues as having arisen for determination in this suit, namely, 1, whether the near complete payments totaling 3,896,375 naira of the claimant's outstanding 29 months local salary of the 5,104,000 by the defendant and admission thereof makes the claimant's suit an academic exercise as the cause of action no longer exists. B, whether the defendant by its counterclaim has proved beyond reasonable doubt that the claimant's purported subsidiary employment agreement was forged and inures this honorable court to grant the defendant's relief sought as contained in the counterclaim. And C, whether the claimant has proved she is entitled to the cost of 2 million naira only and the sum of 5 million naira only as aggravated and general damages. In his written final address filed on the 13th of October 2023, and also deemed properly filed on the 25th of October 2023, learned counsel for the claimants, Kabir Yusuf Esquire, distilled 2 issues as having arisen for determination in the suit, that is, whether the claimant has proved a claim to be entitled to the relief sought before this honorable court, and 2, whether in the circumstance of this case, the defendant's counterclaimant's claim is grantable in law. The claimant's reply on points of law to the defendant's written address was also deemed filed on the 25th of October 2023. In the light of the reliefs claimed by the claimant, the evidence adduced by both parties on record, and the field of disputes between the parties, my view is that the issues as formulated by the learned claimant's counsel adequately covers the fields of disputes in the suit. As such, the court hereby adopts same in determining the suit. In adopting the issues, I should state that I had carefully considered and taken due benefits of the totality of arguments and oral summations canvassed by respective learned counsel in their written final submissions, to which I shall endeavor to make specific reference as I deem needful in the course of this judgment. It must be added that since the focal issue in controversy between the parties in the main claim and the counterclaim are interwoven, a resolution of the issues formulated will have apparently determined both actions at once. This line is in action in consonance with the position of the Court of Appeal in Jeje versus Enterprise Bank Limited citation supply, where it was held per loculo Shodikwe JCS as follows. I quote, indeed, in realization of the fact that the 2 independent actions are tried together is the fact that 2 judgments or 2 decisions are always entered by the court. The first in relation to the main action and the second in relation to the counterclaim. The position of the law is to the effect that where a common question determinative of a claim and a counterclaim arise in a case, the trial court in the circumstance is not expected to consider the said question separately in relation to the counterclaim. End of quote. Now, in proof of the claimant's case, the employment agreements made on the 1st of May 2009 and the subsidiary agreement made on the 1st of June 2009 were attended in evidence as Exhibit C1 and Exhibit C1A. The letter of confirmation of appointment was tendered as Exhibit C1B. By the said employment agreement, that is Exhibit C1, the claimant was engaged by the defendant as an assistant works manager, and upon restructuring of the defendant, its designation was changed to Operation Manager as contained in Exhibit C2. It is further stated in Clause 4.3 of Exhibit C1 that the life of the employment agreement is subject to the Nigeria Immigration Authorities granting the necessary residence/work permits. Further evidence adduced by CW1 to establish the claims are summarized as follows. 1. The employment agreement, that is Exhibit C1, contained only local salary and expenses of 160,000 per month, that is 1,920,000 per annum. The said agreement provides for reimbursement of all authorized expenses of the claimant whilst he was in the defendant's employment. 2. By the subsidiary employment agreement, Exhibit C1A, it was agreed that a payment of $2,000 per month as expected salary be made to the claimant's foreign account with effect from 1st of May 2009. 3. As at 31st of August 2019, the defendant had not paid a total of 29 local salary and 59 months expected salary, and that in spite of several demands, the said salaries and allowances remain outstanding against the defendant. Memorandum written by the claimant for demand of the outstanding salary and allowances dated the 6th of November 2013, 2nd of June 2014, and 27th of March 2018, and the claimant's statements of account with First Bank were tendered in evidence as exhibits C3, C17, C17A, C4, and C4A respectively. 4. By the employment agreement, the defendant is responsible for payment of the cost of residence permits and flight tickets of the claimant and his wife between 2009 and 2019. 5. The reimbursement of the cost of procuring the said resident permits and return tickets between 2009 to 2019 had been submitted to the defendant, but in spite of several demands, the defendant has refused or failed to make the payments. Receipts and temporary expatriate card of Antonio C. Villanueva and Rosenda M. Villanueva, application for renewal of the resident permit for Mrs. Villanueva Rosenda, written by the defendant to Controller General, Nigeria Immigration Service, application for annual leave, and request for 3 flight tickets and receipts of purchase of flight tickets were tendered in evidence respectively as Exhibit C5 to C5G, Exhibit C6 to C6G, Exhibit C7, Exhibit C8, Exhibit C10, and Exhibit C9. On the 13th of April 2018, the defendant wrote Exhibit C11 to advise the claimant to relocate to Kano pending the resolution of his accommodation issue. 7. Due to non-payment of salaries and allowances, the claimant tendered his letter of resignation, that is Exhibit C12, and the acceptance of his resignation was confirmed by the defendant in Exhibit C12 and Exhibit C12B, a letter of no objection to being employed by any organization in Nigeria was issued to him. The claimant instructed his solicitor to make formal demand for the outstanding salary allowances, and in response, the defendant's solicitor requested for particulars of his claims. Correspondences between the solicitor of the claimant and the defendants were tendered in evidence respectively as Exhibits C13, C13A, C14, and C14A. Correspondences between the Ministry of Interior and the defendants, Exhibits C15 to 615A, and the marriage certificates of the claimants, Exhibits C16 and C16A, were also tendered in proof of the claimant's case. Essentially, the testimony of DW1 as the sole witness is that Exhibit C1 is the only employment agreement executed that regulated the relationship between the parties, and he categorically denied that the defendant executed a subsidiary agreement with the claimant for the payment of expatriate monthly salary of $2,000. DW1 alleged that the purported subsidiary agreement, that is Exhibit C1A, was fraudulently obtained and forged by engineer Antonio Comia Villanueva. The defendant denied responsibility for the payment of renewal of permanent residence permits and cost of flight tickets to Philippines for the claimants, as same was never contemplated in Exhibit C1, the employment agreement. DW1 further alleged that a payment of the sum of 1,832,984 naira and 6,680,000 as expatriate resident permits was paid to the claimant's husband's account, even though it was not the defendant's responsibility to pay for it. DW1 further alleged that the defendant paid the total sum of 10,058,122 naira as allowances of fraudulent claims made by the claimant in connivance with the erstwhile managing director and the former acting managing director. In his further testimony, DW1 alleged that engineer Villanueva colluded with the erstwhile managing director, Mr. P. Lewis, now at large, and Mr. George Uyakolam, the former acting managing director, and forged and or fraudulently procured Alhaji Hamadu Abubakar, the former chairman's signature, that a forensic investigation conducted by the defendant indicted him, that is engineer Villanueva, of colluding with the others to defraud the defendant, and that a criminal complaint of fraud and forgery has been made against the said former acting manager. DW1 testified further that an agreement was made by the defendant and the union for 50% waiver of salary claims, which was effective from 8th of August 2017, and further contends that the said agreement is binding on all members of staff, including the claimants. DW1 also testified that as at the time of the filing of the amended statement of defense, the defendant has almost fully paid all outstanding salaries due to the claimant, and the sum of 1,563,000 is the outstanding balance of the salary being owed the claimant. Documents captioned "Minutes of Meeting of Sewin and Management" was tendered in evidence as Exhibit D1. DW1 contends that the delay in the payment of the claimant's outstanding salaries was due to lack of funds, and maintained that the defendant is entitled to refunds of all the money allegedly collected, transferred, or deposited to engineer Villanueva's account, being fraudulent claims that was made in connivance with other members of staff of the defendant. The claimant denied the entirety of the counterclaim and has replied to the amended statement of defense and defense to counterclaim and maintained that both the employment agreement and the subsidiary employment agreement were validly executed by both parties. The allegations of fraud, forgery, and other criminal offenses leveled against the claimant were also denied. Perhaps the starting point is to resolve the jurisdictional issue raised by the defendant in paragraph 16G, sub 3 and 4 of the further amended statement of defense, that the claimant's case is statute barred by the limitation of laws, Kaduna State. I do not intend to waste much time on this issue. It is settled that in order to determine whether or not a court can exercise jurisdiction over a matter, it is the facts averred and the complaint and statement of facts and the reliefs endorsed therein alone that the court is required to examine, and no more. See the cases of Moyosore versus Governor of Kwara State, Guinness Nigeria PLC versus SKA Nigeria Limited, citation supplied. As gleaned from the statement of facts, the claimant's case is for non-payment of arrears of salaries and allowances. The evidence of the claimant has established in Exhibit C13, Exhibit C13A, Exhibit C14, is that up until October 2019, solicitors of both parties had exchanged correspondences in respect of the claimant's demand for the payment of the said arrears of salaries and allowances, and that being aggrieved by the defendant's refusal to make the payment, this case was instituted by the claimant on the 2nd of December 2019. In such a situation as the instant case, the action is not statute barred as alleged by the defendant, and I so hold.
As court pleases.
As the court pleases.
Now, the task the court is to undertake is to examine the evidence on record as adduced by the claimant in order to determine whether or not the evidence has satisfied the requirements of proof imposed by provisions of Section 131 and 132 of the Evidence Act 2011 as amended, to substantiate the claims as endorsed in paragraph 24 of the amended statement of facts. I should state that the case put forward by the claimant is substantially documentary evidence. In that circumstance, the focus of the court is directed principally at the documents tendered by the claimant as the yardstick to assess the oral evidence adduced by the witness. This course is in consonance with the established legal proposition that documentary evidence, being the best evidence, is the yardstick or anchor by which to assess the veracity or credibility of oral testimony, and that extrinsic evidence cannot be admitted to contradict it, add, or vary the provisions contained in a document. See Section 1281 of the Evidence Act on the issue. See also the cases of Skybank PLC versus Akipelu and Nwabueze versus Bauer, citations supplied. From the evidence on record, parties are not in dispute that Exhibit C1 was executed by parties to regulate the employment contract. However, the defendant contests that Exhibit C1A was also executed by parties and alleged that same was forged or fraudulently obtained by Engineer Venezuela in connivance with some members of staff and defrauded, and thereby defrauded the defendant. The disputes between the parties having been clearly identified in the foregoing, the question asked here is whether defendant has effectively raised and successfully proved the elements of fraud and forgery. with reference to particulars of fraud as contained in the statement of defense, learned defendant counsel strenuously conversed that Exhibit C1A was forged by the defendants as the defendant's company logo is not on the said exhibit. Learned counsel further argument in his reply on point of law is that the absence of evidence of handwriting experts is not in all cases prejudicial to the case of the prosecution. In support of his proposition, learned counsel cited the cases of Osondu versus FRN and Akinbisade versus States, citation supplied. Citing the provision of Section 135 sub 1 of the Evidence Act 2011 and the authorities of Umoke versus UBA, Minister of FCT versus Wanes, Consultancy Services Limited, and another, Minister of FCT versus United Power and Energy System, citations all supplied. The submission of learned claimants counsel on the other end is that an allegation of the commission of a crime in criminal or civil proceedings must be proved beyond reasonable doubt. Learned counsel submitted that the defendant's defense of criminal allegation of forgery of signature and fraudulently obtaining a document must be proved beyond reasonable doubt as required by the law. Learned counsel submitted further that the absence of the testimony of the owner of the signature alleged to have been forged is fatal to the case of the defendant. Learned counsel urged the court to grant the claimant's case and dismiss the defendant's case for failure to discharge the burden of proof. It is settled and as correctly submitted by respective learned counsel of both parties that when a party raises an allegation of fraud or other criminal offenses, in its pleadings, a rule of law requires that such allegations must not only be specifically pleaded and supported with particulars, but must also be proved. The reason is to enable a party defending the allegation to understand the case as facing and prepare its defense. See the cases of High Grade Maritime Limited versus First Bank Nigeria Limited, case of Global Formwork Nigeria Limited versus EA Gorem Limited, the case of Michael Ifeanyi Ojiba versus Ojiba, citation also applied. In other words, where irregularity or fraud is alleged, it is not only to be particularized and pleaded, but it must be distinctly proved. It is not allowable to leave fraud to be inferred from the facts. See the case of Akin Omobio Boriowo and others versus Chief Akin Ajasin, Adekunle Ajasin. Then the case of Fabumi versus Egbe, citation supplied. The fulcrum of the case of the defendant is that Exhibit C1A, the subsidiary employment agreement relied upon by the claimant to buttress his claims, as forged or fraudulently obtained. Forgery has been defined as the act of making a false document or altering a genuine document for same to be used. See Agi versus PDP and others, Modibo versus Usman, citation supplied. The burden and standard of proof in cases involving forgery is like in criminal matter, even if it is alleged in a civil matter. The burden is on the person alleging, and the standard is beyond reasonable doubt. The Supreme Court made this point in Fagbumi versus Agbe, 1985, One Nigeria Weekly Law Report, Part 2 at page 229, where Obaseki JSC held at page 319 that, I quote, fraud is a serious crime and in civil matters, the particulars must be pleaded and proved strictly, end of quote. See also the case of Oga versus Ikweazu and others, 2017, 5 to 6 SC, Part 1 at page 1. Now, the naughty question begging for an answer is, did the defendant comply with the above positions of the law? I have perused through the further amended statement of defense with a fine-tooth comb with the aim of deciphering compliance or violation of the above displayed positions of the law. Paragraph 3E of the further amended statement of defense contains the particulars of fraud. The particulars are stated as follows. 1. The signatures contained in the purported subsidiary employment agreement is not the authorized signature of the defendant and were appended before the document was made. 2, the document does not exist in the records of the defendant. 3, there is an alteration therein which was not countersigned or authenticated by any of the authorized signatories of the defendant. 4, the said fraudulent alteration and the forged signature were done before the alleged document came into existence or was dated thereby, rendering the said document invalid. 5, the signature of the claimant's husband was not witnessed, as was done in the employment agreement of 1st May 2009. 6, the defendant's chairman did not sign any subsidiary agreements. I had painstakingly examined the evidence on record, together with the particulars as listed in 1 to 6 thereof. Items 3, 4, 5, and 6 of the said particulars are unsupported by evidence on record. A crucial examination of Exhibit C1A shows that, contrary to the defendant's assertion, the alteration on the date was countersigned. Furthermore, the signature of the chairman was also not witnessed as the claimant's signature, and more importantly, the chairman was not called to testify that his signature was forged. The testimony of DW1 is that a forensic investigation was conducted by the defendant which indicted Engineer Venezuela of colluding with others to defraud the defendant, and that a criminal complaint of fraud and forgery has been made against the said former acting manager. However, there is no iota of evidence to prove these assertions. Neither is there evidence that the signatures in Exhibit C1A were unauthorized signatures of the defendant's signatories, or that the said signatures were appended before the document was made. Under cross-examination by the learned claimant's counsel and upon being shown Exhibit C1A, DW testified as follows, I quote, "This is not the employment agreement of the defendant. The employment agreement ought to have the company's logo and other necessary details," end of quote. My understanding of the above testimony is that the allegation of forgery of Exhibit C1A is predicated on the fact that the said exhibit does not have the defendant's company's logo. I had undertaken a careful look at employment agreements, that is Exhibit C1. The said agreement also does not have logo of the defendant. It is also on record that upon being recalled under cross-examination by the learned claimant's counsel, DW1 testified as follows, I quote, "The accounts department of the defendant prepares documents like Exhibit D3 for all members of staff. It is true that salary cannot be allocated by staff without the approval of the account department and based on the approval of the management," end of quote. As correctly submitted by learned claimant's counsel, the piece of evidence that salary cannot be allocated by staff without the approval of the account department clearly exonerates Engineer Venezuela of the commission of the crime of fraud and forgery. My finding is that the defendant has failed woefully to discharge burden of proof of fraud and forgery as alleged against Engineer Venezuela. In the result, I endorse in total the claimant's telling arguments that the defendant has not proved beyond reasonable doubt that Exhibit C1A was forged or fraudulently obtained. Failure to discharge the body is inimical to the defendant's case and a flagrant defilement of the law. And I so hold. Having failed to prove that Exhibit C1A was fraudulently made or forged, my finding is that Exhibit C1A was validly executed by both parties, and I so further hold.
Scott places.
With reference to Exhibit C4 and Exhibit E, the further submission of learned defendant's counsel is that the claimant had admitted on the cross-examination that the defendant had paid and still paid the claimant's husband's outstanding emolument after the case was instituted. Can that device be muted? Whoever is on mute, please. Who is 07822? Can you mute your device, please? I go again. With reference to Exhibit C4 and Exhibit D, the further submission of learned defendant's counsel is that the claimant had admitted on the cross-examination that the defendant had paid and still paid the claimant's husband's outstanding emoluments after the case was instituted. Learned counsel argued that by the reason of the admission, the instant suit becomes academic. I'm waiting for you to conclude your conversation. 02822. Can you mute your device, please? I do not agree with the submission of the learned defendant's counsel that the present suit discloses no life issue or that the suit is not justiciable. CW1, upon being recalled, testified under cross-examination as follows. I quote, "I have access to my late husband's account. After his resignation, the defendant was still paying money even though it is not the actual amount. I agree that the money paid to my late husband's account is part of the money the defendant is owing him," end of quote. It can be deduced from the above testimony that during the pendency of the case, only part of the money being owed was paid by the defendant, and as gleaned from the reliefs in paragraph 24 of the amended statement of facts, other reliefs are being claimed. Learned counsel's argument that this suit is academic is hereby not countenanced. In the same vein, the admission of the defendants in paragraph 21 of the further amended statement of defense is that the defendant has been meeting up with its obligation by paying the outstanding monthly salary, and that as at 31st December 2021, the outstanding balance of the salary being owed is 1,563,000 naira. It is a settled position of law with statutory backing and a legion of decided authorities that what is admitted needs no further proof. See Section 123 of the Evidence Act 2011 and the authorities of Akelago versus Oshobajo, Ojukwu versus Owunduwe, and others. Citation supplied. Having regard, therefore, to the defendant's unequivocal admission of liability to the outstanding balance of the claimant's entitlement for the salary, I must state that the claimant is entitled to the sum of 1,563,000 naira admitted by the defendant, and are so hold. Now, apart from the payments of outstanding local salary, the claimant also claims the sum of $118 as the unpaid 59 months outstanding expatriate dollar salary, the sum of $6,005,000 and $7,031,000 as cost of procuring expatriate resident permits and cost of round trips from 2009 to 2019. As gleaned from the facts of the case, the relationship existing between the claimant and the defendant is one of ordinary master and servant, governed by written agreements and not subject to statutory flavor. What this readily portends for the parties is that in construing the terms and conditions of the relationship, the parties practically have nowhere else to look for the determination of the terms of relationship but the written contracts existing between them. It is an elementary principle of contracts, and indeed well settled, that parties are generally bound by the terms and conditions of an agreement which they voluntarily entered into. It is equally trite that the courts are bound by the terms of an agreement which parties before it have freely and validly executed. Thus, if a court is called upon to construe an agreement, the court cannot but limit itself to the express terms of the agreement as indicated or as specified by the parties. This is because where the parties have embodied the terms of their contract in a written document, extrinsic evidence is not admissible to add, vary, subtract from, or contradict the written terms of the contract or agreement. Therefore, when a court is faced with the task of interpreting a written instruction or agreement from one party to other or between two or more parties, as the case may be, it is expected that it will carry out its duty within the walls or confines of the written and express terms of the instruction or agreement. See the cases of Baba versus Nigeria Civil Aviation Training Centers, Zaria, Union Bank of Nigeria Limited versus BU Ume and Sons Limited, Koiki versus Magnesium, citation all supplied. On this premise, the material question is, what are the terms as agreed by the parties? I turn to examine the terms and conditions in Exhibit C1 and C1A applicable to the claimant's contracts of employment. The provisions of Exhibit C1 relevant to the determination of the present case are clauses 4.3, 5.2, 11.1, and 14.3. Clause 4.3 provides that the agreement is subject to Nigeria immigration authorities granting the necessary residence work permit. Clause 5.2 provides that the company will reimburse the reasonable and duly authorized expenses of the employee in connection with the exercise of his duties upon presentation of relevant documents. Clause 11.1 provides that each full year of service and in connection with his annual leave, the company shall pay the employee and his wife to return airline tickets from Nigeria to Philippines, whilst clause 14.3 enjoined the employee to conform conscientiously to the laws and regulations of the government of Nigeria. In Exhibit C1A, the company, in addition to the terms and conditions as stated in Exhibit C1, agrees to pay the employee a monthly salary of USD 2,000 to an overseas bank account to be designated by the employee. Exhibit C4 and C4A, Exhibit C5 to C5G, Exhibit C6 to C6G, Exhibit C7, Exhibit C8, Exhibit C9, Exhibit C10 were tendered in evidence to prove the claimant's case. The evidence of record is further that the reason for the resignation of the claimant's husband as contained in Exhibit C12 was for non-payment of salaries and allowances for over 4 years. A demand had been consistently made for the outstanding salary, and as stated in Exhibit C3, this included local allowances and expatriate allowances. The evidence on record is that defendant accepted his resignation, but yet failed to pay the outstanding salary and allowances in spite of several demands by the solicitors of the claimant's husband and written demand for payment after his demise. Perhaps I should also remark on the defense advanced by the defendant in paragraph 8C of the further amended statement of defense that the defendants and union members, including the claimant's husband, had an agreement to waive salary claims by 50%. In paragraphs 13 and 14 of reply to the statement of defense and defense to counterclaim, the claimants denied being a member of the union. Exhibit D1, the minutes of the meeting merely stated that the claimant was in attendance. It was preposterous of the defendant to allude that a minute of meeting will translate to an agreement. The defendant has the onus to prove that the claimant was a member of the union but failed to discharge the burden. The minute of meeting as contained in Exhibit D1 is not binding on the claimant's husband, and I so hold. I'm quick to remark that the documents Exhibit C5, C6, and C9 series tendered in proof of the claims for payments of cost of procuring expatriates resident permits from 2009 to 2019, the cost of round trips tickets to Philippines from 2009 to 2019 were merely dumped on the court. In simple terms, dumping a document in court during trial means putting the document in evidence as an exhibit without the vital evidence of witness or witnesses to relate or link it to the specific aspects or part of the case in support of which the document was tendered or put in evidence by the party. The court cannot assume the duty of tying each exhibit to specific aspects of the claimant's case when same has not been done by the claimant. The foundation of the principle is that it is an infraction of fair hearing for the court to do in the recesses of its chambers what the party has not himself done in advancement of his case in open court. See the cases of Idea Trading Manufacturing Limited and another, Tropical Commercial Bank, the case of Numatura Nigeria Limited and another versus First City Monument Bank PLC, citation supplied. Having regards to the fact that the claim is hinged on proving that the defendant failed to reimburse the claimant for the expenses as alleged, and having not proved that the said exhibits covered for the duration of the period of 2009 to 2019 as claimed, the claimant is not entitled to relief 3 of the claim, and I so hold. In the overall analysis, my finding is that by the overwhelming documentary evidence, the claimant has proved that her husband was engaged as expatriate, and having held that Exhibit C1 was validly executed and binding on parties, the claimant is hereby entitled to reliefs 1, 2, and 4 of the claims. And I so hold. In totality, the claimant's claim succeeds in part. For the avoidance of doubt and abundance of clarity, judgment is hereby entered in favor of the claimant in the following terms. 1, a declaration that the claimant is entitled to payment of all outstanding salaries during the period her husband worked for the defendant. 2, an order directing the defendant to pay to the claimant the sum of 1,563,000 naira as outstanding balance of the monthly local salary. 3, an order directing the defendant to pay to the claimant the sum of $118,000 only, being unpaid 59 months expatriate salary. 4, an order directing the defendant to pay the claimant the sum of 1 million naira as general damages. 5, it is hereby further ordered that the defendant shall pay the sum set out in 2, 3, and 4 above within 30 days to the claimants, failing which 10% will be interest will be considered on the judgment sum from the date of judgment until it is fully liquidated. Now, to the counterclaim.
Okay.
As the defendant discharges the burden of proving his entitlement as claimed, as correctly submitted by learned claimants counsel, there is no doubt that a counterclaim is a separate and distinct claim from the main claim. To put it differently, the same standard of proof required to prove the main claim is also required to prove the counterclaim. See the cases of Attorney General of Lagos State versus Attorney General Federation, the case of Ogli Oko Memorial Firms Limited and another versus Nigeria Agricultural and Cooperative Bank Limited and another. The defendant's counterclaim as contained in paragraphs 31, 32, 33, 34, 35, 36, 37, and 38 of the further amended statement of defense and counterclaim is premised on the fact that the subsidiary employment agreement, that is Exhibit C1A, was fraudulently obtained and forged by the claimant's husband and thereby rendered invalid. Having held earlier that the said Exhibit C1A was validly executed by parties, and having held that parties are bound by the agreement, the counterclaim fails in its entirety and is hereby accordingly dismissed.
As the
Parties
court pleases.
shall bear their respective costs. This is the
As the
judgment
court pleases.
of the court.
As court pleases.
As the court pleases.
My Lord, we
We are
are
most grateful.
mostly grateful and thankful for your wisdom, and we pray you go up the ladder beyond your expectation, and we pray God guidance and protection for you and your family. Thank you, my Lord.
Amen.
We also appreciate the court for the industry time taking. We so much appreciate and wish my Lord the very best going forward.
Thank you. As you know, this
And
judgment.
I also congratulate my learned colleague on the other side.
Thank you, my friend.
Okay. I hope the congratulation will be sustained.
As
But
court
for
pleases.
whatever
My Lord,
reason
there's
you
always
want
this-
the judgment
you,
will be
my Lord.
transmitted by the end of next week, knowing that it is being delivered in Abuja division. So getting it across to Kaduna may be a bit of a challenge, but in as much I will try my best to get it across by the end of this week so you can apply for it as from next week by God's grace. Already you can see it's being read, it's being typed, it's just to print and sign, but getting it across, except I have somebody going to Kaduna division this afternoon, it will be transmitted. But like I said, by early next week, you can apply for the judgment. Thank you, gentlemen. The court will rise.
as the court pleases.
Thank you.
This network today.
Oh. Oh. Mm. Okay. Yeah. Oh. Mm. Oh.